In the last lecture, we talked about registered land and the Land Registration Act 2002, but a lot of land in the UK is still unregistered, and so it's important for exam purposes that you know some of the principles associated with unregistered land as well. And that's what we're going to be covering in this lecture. So without further ado, let's get started. The first distinction that we need to make when it comes to unregistered land is the difference between legal and equitable interests. And whereas legal rights are binding on the entire world, equitable rights are binding on everyone except for the bona fide purchaser of a legal estate for value without notice. Now, there's a lot in that phrase, and it would be quite useful if we broke it down. So let's do that now. The first thing is bona fides, which is literally translates from the Latin as good faith. And so the absence of notice has to be genuine and honest, and that comes from Midland Bank Trust Company and Green from 1981. It also means that there's a possibility of using constructive notice and applying that to a purchaser. And we can look at cases like Ives Investment and High from 1967, which we've not put down on the slide, but is a good example of use of constructive notice that we'll talk about in a little bit. The purchaser of a legal estate, that's generally self-explanatory, but it also means that it covers lenders who take a charge of the property by way of a legal mortgage, and that's important coverage for this purpose. So the authority for that is section 87(1) of the Law of Property Act 1925. For value means that there has to be money that's exchanged in return for the property. So people who receive the legal estate as, say, a gift, or people who are squatters, will not be covered within this definition. The absence of notice can include a number of things, so that's actual notice, where a person is directly informed of a right, constructive notice, which can be applied where a purchaser has failed to inspect the land or the title. Generally, the courts are a little bit reluctant to impute knowledge onto another person, but for constructive notice, there's a reasonable expectation that a careful purchaser will, at the very least, inspect the land and the title. And the case authority for that is Hunt and Luck from 1901. We can also have imputed notice, and this is where a person's solicitor has knowledge of an equitable right, but they do not inform their client. And so the client is imputed to have had notice of the rights under the land. And that might seem a little bit unfair if it's the solicitor's fault, but then the person or the purchaser would then be able to sue the solicitor for negligence. But what about this concept of notice? When is a person said to have notice of equitable rights? Well, before 1925 it was very vague, but things like the Law of Property Act and the Land Charges Act from 1925 generally sort of rationalised this area of the law quite a bit by creating the Land Charges Register. And this means that notice is unavoidable if an equitable interest is actually covered on the Land Charges Register. And most rights are nowadays. The only point to add to this is that notice is irrelevant when the rights are lost through statutory overreaching. And you can look to the Law of Property Act 1925 for more details on that. We also covered overreaching a little bit previously in the context of London Building Society and FLEG. So let's think about this Land Charges Register though. What equitable rights does it actually cover? Well, these are lettered, and A and B both refer to rights which arise under a statute. C is split into 4 different subcategories. So we have Puisine mortgages, which is legal mortgages without a sort of formal document to cover them. Limited owner's charge, as well as general equitable charge, and then C4, which is estate contracts, and this can include any contracts associated with the legal estate. So we're thinking in particular about contracts for transferring the legal estate, but it also covers options to purchase the legal estate and rights of preemption as well. And you'll notice I put C4 in bold typeface, and that was a deliberate choice, and we'll explain why that's important in a little bit. We've also put D in bold as well. That covers inland revenue charges under the Inheritance Tax Act. also covers restrictive covenants and equitable easements as well. E is not really too relevant nowadays because it refers to annuities created before 1926 and that aren't on the annuities register. F is still relevant though and derives from the Family Law Act 1996 and references the protection of home rights under that legislation. So why are some in bold and some not? Well, if you generally fail to register an equitable interest, then that equitable interest in the land is lost because the law is essentially favouring the certainty of the land charges register over the interests of the people who have equitable rights in the land. Now, there are some exceptions to this, and this is for particularly important rights, which are the ones that we listed in bold. So C4 land charges and Class D land charges as well. And these are generally lost, but there is an exception so that they are retained when you're dealing with a purchaser for money or money's worth of a legal estate in the land charge. So there is a sort of slight exception there for important rights, and that quote derives from section 4.6 of the Land Charges Act 1972. Now the final question we have to ask then is, thinking back to right to the very start of the lecture, how do we actually apply this bona fide purchaser rule? In other words, we know that legal rights are binding on the entire world, but equitable rights are only binding on the bona fide purchaser without notice. So working from this, we can sort of say that most of the equitable interests a purchaser is going to have notice of because they're covered within the land charges register. However, there are some minor equitable interests that aren't covered in this, and in particular, a purchaser from a sole legal owner holding on an implied trust takes free of adverse beneficial interests if he ranks as a bona fide purchaser of the legal estate without notice. And that comes from the 1969 case of Caunce and Caunce. So essentially what we're saying here is that equitable rights are generally covered in the land charges register, and an inspection of that register means that a purchaser will have notice. So this idea of a bona fide purchaser without notice is very limited nowadays, and there's only sort of this very limited exception dealing with sole legal owners on an implied trust. And that covers unregistered land. Now, as with registered land, you can see that the law in this area is trying to create as much certainty as possible. So we know that legal rights are binding on the entire world, and equitable rights are nearly binding on everyone, but there has to be an awareness of what is going onto the land charges register, and that's another way of establishing certainty around equitable rights in the land for a purchaser who is going to discover them on exploration of the title to the land that they are purchasing. If this comes up as perhaps an essay question, then you might want to discuss the advantages and disadvantages of the registered and unregistered land systems, and how the registered land system tries to establish even greater certainty than the unregistered system. If this comes up as a problem question, then you want to look at the different legal and equitable rights and discover how they're covered within either the land charges register or discussion of that bona fide purchaser for value without notice. Well, I hope you've enjoyed this lecture. If you did, make sure to leave it a like, subscribe for more videos in the future, and if you've got any questions or comments, then leave those below and I'll try and get back to you. Thanks very much for watching. Bye!